The HR Stories podcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the website, thehrStoriesTeam.com, and learn more about how the team at HR Stories can support your business or nonprofit. Have you ever wondered why a company would do something so stupid that it cost them their brand reputation, hundreds of thousands of dollars, and some of their best employees? Each week, management and HR consultants, John Thalheimer and Chuck Samikian, dive into the stories that matter and discuss the lessons and what we should do to protect our organizations. Welcome to the HR Stories podcast, where there is a lesson in every story. On this week's episode, John and Chuck talk about highly compensated employees. But first, here's what's happening in human resources news.
What is happening in HR news this week? There's a lot going on, John. Good to be back with you today.
Good to be back with you, Chuck. What's going on in your life? What's been happening this week? I know you've been busy doing some stuff. What's going on?
Yeah, well, I wrapped up a big sexual harassment investigation. Folks, I have to tell you, listeners, if you work for a company, if you have any influence with your organization, you've got to do your sexual harassment training, especially if you have 15 or more employees. The EEOC says that you're basically liable. If you don't do sexual harassment avoidance training or making your folks aware, especially your management team, and you get caught up in something, you have no defense. And so that was interesting this week. It was not an EEOC thing, John. It was just hey, we have this going on. So I conducted a bunch of investigations and wrote up a big report, and it takes time. But that's what I spent most of my week doing.
You know, it's great, Chuck, because this week I was working with a client and we were talking about sexual harassment investigations and how to do it. And I pulled up our checklist, the ultimate book of HR checklist, and your checklist in there about, it comes from your experience, but all the things that you need to do it's such a great tool for small business owners. And this client was happened to be a small business owner, to go through and go, all right, this is what I need to do. All right, this is how I'm going to do that. And of course, sometimes they need to bring in us, right, HR consultants to kind of do that. But they can do a lot of it on their own. And the checklist is so good. And I thought you did a good job. So I want to kind of give you kudos for that because it was helpful for me with one of my clients. So thank you for doing that and making that happen.
Yeah, awesome. Thank you. In addition to like sexual harassment and discrimination and that sort of thing, there's some really interesting things in the news coming out. I know we're waiting for a big Supreme Court decision right now. It's a postal worker that has asked the U.S. Supreme Court to review this lawsuit that he has where the post office, he feels, should have fulfilled his religious accommodation request for Sundays off. And, when you think of post office workers, I don't normally think of them working on Sundays, but now with, all the Amazon and all these delivery packages, I do know that post office workers do work Sundays. And this person said, I can't work it. And they made him work. He was told to swap shifts with other coworkers to avoid working Sundays. He just wasn't found anyone. And so he was disciplined, and I believe he might have been ultimately fired. So we're waiting for a Supreme Court decision on that. I know it will affect the hospitality industry and service industries overall.
Yeah,
so a lot of times people can't or don't want to work on Sundays due to religious reasons. So that's a big one.
Yeah, I think that's a big one. The one that's fascinating to me, because when we typically think about employment law, the Federal Trade Commission doesn't come up a lot in our conversations. But they're talking about non-competes right now, and they're proposing a non-compete ban, really. And so I think probably by the time we launch this podcast, the public commentator period will be over, but we should be listening and paying attention to see what comes out of that probably this summer, and then subsequent lawsuits behind that. Whether they have the authority to do that or not will be interesting to kind of see. I was talking about this in my class yesterday. I kind of go in both ways. I get the need for having non-competes for certain roles and positions, but I do think it's crept up. I mean, the story I always tell is there was a fast food restaurant type place where they're like to their grill cook, sorry, you have a non-compete. You can't go work in any restaurant within 100 miles. And it's like, you can't make a living then, right? That's not fair to a grill cook, right? It's kind of ridiculous. And so I think redefining how we look at non-competes, I think could be really important conversation. So it'll be interesting to see where that ends up and how we do that. So lots of good things in the news as well. What else is hot for you? Yeah,
well, this just kind of came across the desk. This is a Papa John's pizza place in Athens, Georgia. There's an EEOC is taking up this case where they're saying they violated the Americans with Disabilities Act when they fired a worker who needed his service dog to commute to work, right? So, interesting in this story, as we tell stories on the HR Stories podcast, the worker was informed by the store manager of his accommodation needs before applying. They said, hey, no problem. Your disability nor your need to keep the dog on site, which they asked would be out of customer view and out of the food prep areas. That's not going to present an issue. So, but then after he was hired, I don't know what happened, but apparently he had to submit some sort of accommodation request, and then he was told his request was denied and he'd be terminated. And they said the dog would be a health and safety risk. And so I don't know a lot about this story because it just came across the news. Did the company go through the interactive process? Why did they say we will hire you and now we are firing you? Are there maybe local health regulations saying something about the dog? Although I have to tell you, the employee just asked, I need the dog to commute to work. I don't need the dog at work in the pizza area, right? So it sounds to me like it could have been a reasonable accommodation to find a place for this dog, especially if the manager said, no problemo, right?
Right. It's interesting, right? So I'm assuming Papa John's are mostly franchise. And like, who was doing the interview? Did the hiring manager say, oh yeah, that won't be a problem, that's fine? And then it went up to the franchisee corporate headquarters and the HR person's like, you can't say that's fine. How are we going to do with that? We can't have a dog there. What about other people, right? Or maybe vice versa, right? And so again, being consistent across your organization is going to be critical so you don't run into situations like that. Always really important to kind of get across. So that's an interesting article, and we'll keep following that. That may become a story.
Yeah, I want to follow because it's interesting. There's a lot of depth into this where, employers often cite health and safety reasons, but there was an EEOC panel not too long ago that said, while food service areas and patient waiting rooms should be very clean, there's no expectation of sterility, and service animals should generally be allowed. But like we say on the HR Stories podcast and everywhere else, it depends, right? It depends. We need to look at it. It could be a number of variables, but the bottom line is you have to go through that interactive process and try and find out how can we make an accommodation rather than looking at it from how can we figure out how not to make an accommodation.
Right. Yeah. That's a good point, right? There are a lot of things going on that kind of getting up. There was OSHA put out to their regulators and their field techs, their field people, about how they are going to allow instant by instant reporting, so they can charge you they can give you a fine per instance. So instead of coming in and looking at everything as a whole, they can be like, hey, this is an instance right here. You're going to get fined for this. Here's another instance. You're going to get fined for that. And so we're expecting to see OSHA fines go up a little bit for those companies, not a one-time incident, but those companies that are repeat offenders. So people should be paying attention to that. We're seeing some of that in the news as well.
Yeah, so many times some of these companies will figure out, okay, it's going to cost me X number of dollars to fix this item or to do a number of things. It's not going to cause death, but OSHA doesn't like it. But if they're only going to fine me X number of dollars, I'll take the fine and move on.
Right. Yeah. I mean, again, it's that risk benefit analysis, not what I would suggest.
No.
Right. Yeah. I'm not suggesting that at all. But I think, again, it's something that people think about. And so what's happening now is OSHA's going, hey, we're aware of that. And if you continue to do that, their fines are going to get bigger and deeper. And so you need to be paying attention, and especially when it comes to the health and safety of our employees. We want to make sure that we are doing everything right. And I know I've run into situations where I'm like, oh, come on, OSHA, why do we have to do that? That seems silly. Our employees are there. We're not changing any of the protection, but that's their policy. For something could happen, right? And so again, we always want to make sure that our employees are safe on there as well.
And John, we got some exciting news to share about our new book, The Ultimate Book of HR Checklists, Getting HR Right, was approved this week by SHRM. It's a SHRM approved book, Society of HR Management. They have picked it up. They're going to be offering it. Not only can you, our listeners, get it at hrchecklists.com. That's hrchecklists.com.
You had to add the S.
What's that?
You had to add the S.
I had to add the S. HR Checklists.
Yeah.
But what happens is SHRM will be picking it up, offering it in their bookstore. They've approved it for 3 recertification credits. So if you are a certified HR person, you have to get recertified every 3 years. Yeah. So that, I think, gives us that extra bit of fun credibility. Of course, I knew it was a credible book anyways, but now SHRM approved, Society of HR Management. How about that?
Yeah, and I mean, I think the big thing is not for us, right? I mean, of course, for having that SHRM approval is great. But it's for our listeners and the people that get the book. Now you get 3 PDCs, professional development credits, towards your SHRM certification, right? You got to get 60 in 3 years. This is 3. It's an easy way to get them. We believe, and I kind of know, I'll say I'll believe, but we believe that once you get the book, you're going to use it pretty much at least once a week. You'll be using
absolutely.
it.
This is
go
not
back to and use it. It's one of those books. It's not a reading book. It's a checklist book where you use it every day. And the people, I was down your way, Chuck. I was doing a presentation in Florida for one of our clients. We both have worked with this client doing performance management, right? I was doing a thing on performance management, and I was sitting next to Diane, who has the Ultimate Book of HR Checklist, and she was telling me how useful it's been in her situation. Just to kind of put this around, she is she's not an HR person, right? Not per se, she's not an HR person, but she oversees the HR function in her company. And so she was like, oh my goodness, I can open this page up and look at it, and it becomes a great thing. So again, good conversations, kind of thinking about the benefit of the book itself and what it can do for your organization. But that SHRM is kind of, I think we should be proud, Chuck.
Yeah, it's like we
shouldn't probably, be proud on our podcast. But I just, it's something that I think will help our listeners as well as make us proud.
Yeah, it's the cherry on top. So that's exciting. Lots of stuff going on. Folks, hopefully if you caught last week's podcast, look in the show notes. We've got some, if you sign up for our newsletter, you'll get as a bonus a couple of extra checklists that we created that will go into the 2024 edition, but you can get them now if you sign up for our newsletter. And if you want to see more about the Ultimate Book of HR Checklists, just go to that website, hrchecklist.com. If you click the Buy Now button, first of all, you could scroll down, read a lot of stuff, or you can click the Buy Now button and you could actually download a free sample, and you can see a video of the HR Checklist book in use.
That's great. That's fantastic. Yeah. All right. So, Chuck, I think you got a story about us paying employees too much or something. Something about people being too highly compensated or something. I'm confused. I want to get into it, but I think we want to take a break now. We'll take a quick break, everyone, and we'll be back. And we're going to be talking about FLSA, so the Fair Labor Standard Act, highly compensated employees, which is a very complicated story. So
yeah, and it's a recent Supreme Court decision, so that just adds a little more complication into it.
More gravitas to it.
All right. See you on the other side.
Be back.
Hello, listeners. I have some questions for you. Do you find yourself struggling with HR and employment issues? Are you afraid you could make the wrong employment decision that will cost your company thousands or even millions of dollars? Maybe you're new to the world of HR, or you've been in HR for a while and you just wish you had one resource, a guide to help you get HR right. Well, I've got good news for you. The team at HR Stories is excited to announce a new comprehensive resource, the Ultimate Book of HR Checklists. We created the Ultimate Book of HR Checklists as a simple, step-by-step resource guide packed with 70 downloadable checklists and other resources that help small businesses and organizations get human resources right. Even with very little HR or management experience, you can get instant results with concise, practical steps for addressing many of your tough employment issues. Do not miss out. Go to hrchecklist.com to learn more. That's hrchecklists with an S.com to learn more. And as always, thanks for listening to the HR Stories podcast, where the lesson is always in the story.
Okay, so this is a bit of a complicated story. Well, the actual story is short. Although the Supreme Court write-up was over 31 pages, but the fallout from the story is actually the real story. Did we follow me?
I'm not really sure if I did.
Okay, exactly. It can be a bit of a mind twister. So let's just lay out some basic info and we'll build from there.
All right, good. You got me a little nervous. You make me nervous with your stories. But I think I'll be all right. I know you're good at guiding me to where I need to be. But today I will be like the listeners, and I am a little nervous where you're going to take us.
All right. So great. Yeah, I mean, you know what the FLSA is. Of course you do, right? The Fair Labor Standards Act.
Yeah, right. Of course. Chuck, this is the HR Stories podcast. We mention the Fair Labor Standard Act at least once every 2 stories. Sometimes to the point that it's too much, but yeah, I get it. All right. So we're going to talk about the Fair Labor Standard Act. Came out in 1938. Okay.
Absolutely. The granddaddy of all. So just making sure our listeners are up to speed. So the FLSA requires most employees in the United States to be paid at least the federal minimum wage for all hours worked and overtime at not less than time and a half of their regular rate of pay for all hours in a 40-hour work week. So basically,
just to be careful, everyone, right? Because Chuck is putting out the federal law. Your state may differ, right? And your minimum wage may differ, right? And so we all know that the federal minimum wage is $7.25. However, your state, your locale, your county, your city may have a different minimum wage and different overtime requirements. So it's something to be paying attention to now. We try to talk about states a little bit here in this podcast, but it's a little hard because we have listeners from all over the country. So just as a reminder, some research for you to kind of know what that is for your area. Sorry, Chuck, didn't mean to interrupt you.
That's okay. But there is a section in the FLSA that provides an exemption from overtime pay for certain employees. Those are what we call overtime exempt or exempt employees. A lot of times they're known as salaried, right? Salary versus hourly, exempt versus non-exempt. So, but to qualify for the exemption, employees need to meet certain tests regarding their job duties and to be paid on what's called a salary basis. Let's keep that in the back of our mind because that's key to today's story.
Salary basis, I got it.
Yeah,
right.
Not less than $684 per week. And they also need to be employed in their duties, right? Well, as what they call an executive, an administrative, professional, outside sales employees, also certain computer occupations.
Right.
And to be an executive employee and what we call thus be denied overtime pay, an employee must meet some criteria, 4 criteria that, hey, I'd love to pull out of the ultimate book of HR checklists, Getting HR Right.
Okay, good. Pull it out.
All
what
right,
does it say, Chuck?
It says, number 1, the employee must be compensated, and I've kind of touched on this, but on a salary basis, not less than $684 per week. And as we say, and as you said, please note, this is the federal level. Your state level could vary. Number 2.
I know, sorry, Chuck. I know that off the top of my head, I think California's at like $62,000 a year, a little more than 62. Colorado's at 45, Maine's at 41. New York, it's done by county. It's crazy up in New York State. So just be aware. Again, I'm throwing that out, probably getting in Chuck's flow, but just want to make sure that we're covering all those things. So good.
Sure. And you know, John, I just want to tell you, this gets people tripped up, got me tripped up years ago, hearing the word executive exemption, right? You might think, oh, they got to be these top executives, but it's not. It's usually any of your managers or your department leaders, they're considered, they usually fall under this exemption.
Yeah.
Because the employee's primary duty, even though they call it executive, the employee's primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. That's number 2.
Okay.
And then number 3, to be in this executive exemption, they must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalent.
Yeah,
So,
the one word that we have to make sure that's in there, it should be 2 other full-time or their equivalent, right? So it's not them, it's 2 other ones in there. So just being aware of that. I just love that they put the word other in there. I find that humorous in my nerdy FLSA way. So.
Well, they were really thinking things through back in 1938. Jiminy Crickets.
Wow.
So, and then the employee must have the authority to hire or fire employees, their suggestions or recommendations as to the hiring, firing, advancement, promotion, other status changes of employees, but they need to be given particular weight. They're not just a, hey, we're going to move you here and we don't care about your opinion. Their opinion should carry weight.
Yeah. And so that's the executive exemption, correct?
Yes.
And there's other exemptions as well, right? And so I know we're not going to get into the granular of the details for that each one of those, but be aware that there's other ones as well.
Yeah. Well, the executive exemption is important for today's story.
Okay.
So,
got it. Okay.
yeah. And when we talk about pay and overtime and not overtime, we don't normally go, one thing we don't normally get into deep because it doesn't occur that often, but the regulations also contain a special rule for what is called highly compensated employees, the HCE. And those are people that are paid a total annual compensation of $107,432, but just say $107,000 or more per year. And a highly compensated employee is deemed exempt.
Yeah, and so just to be clear, you mean exempt from overtime?
Yes.
Okay.
Yes.
And I'm sure most of our listeners know that, but there may be one or two that just don't. And so I just wanted to kind of throw that out there. So exempt from overtime. Got it.
Yeah.
So sorry to interrupt again. So.
And it needs to be paid on a salary, and they use the term fee basis, but basically a salary basis. That's the summary. It goes deeper, and that's key to today's story today. The employee's primary duty includes performing office or non-manual work, and they need to perform at least one of the exempt duties or responsibilities of an exempt executive, admin, or professional employee.
I just want to add another thing. When you're talking about that compensation, that $107,000, again, I think one of the things that's really important is that they have to be paid at least $684 per week, meaning they can't get that all in bonuses once a year, right? Mm-hmm. They have to be paid that money on a salary basis, not all of it, but at least $684 per pay period, per week on there on a salary basis. So I think that's an important thing to kind of note on there.
Sure. And the other important thing that I'm not getting into the granular of the law, but it's important. I will, because they say it has to be done on a weekly, monthly, or yearly basis. Okay. That's what the actual law says. It plays into today's.
Yeah, that's part of the story, right?
It is. So an employee could qualify as an exempt, highly compensated employee if they meet these items. Okay. So with our story, there's a gentleman. All right, man. His name was Mike. His name was and still is, by the way. Michael. Yeah, Michael Hewitt. So Mr. Hewitt, Michael Hewitt, worked for this group called Helix Energy Solutions Group, and he did it for about 3 years, from 2014 to 2017, and he worked in an offshore oil rig, and usually he worked 84 hours a week, which is not uncommon. If you're living out on these oil rigs, you're working a lot of hours.
Yeah.
And he oversaw parts of the rig's operations. They called him a tool pusher. Right.
Okay.
So interesting. Yeah. That was the title, tool pusher. I thought I'd throw that out there because I love interesting job titles. So he was a tool pusher, and he supervised 12 to 14 employees. And what he would do is he would usually alternate, have 28 days out on the platform, and then working these 12-hour days, 7 days a week, and then 28 days off the platform.
Okay.
And Helix Energy paid Mr. Hewitt on a daily rate basis with no overtime exemptions. And I think, I read it was about $963 a day is what he would get.
So was he paid every day? Was he getting a deposit every day? Or they would just at the end of the 28 days go, all right, well, we paid you $963 for this day and then $963 for this day. And so we added up, times it by 28, and then would give them that would be the money they got? No,
he was actually paid twice a week. So
he's paid twice a week.
Yeah. So the paychecks were issued every 2 weeks, and it amounted to his daily rate times the number of days he had worked.
So his paycheck was every 2 weeks, not twice a week.
Yes. Yeah, it was every 2 weeks.
Sorry.
Yeah, sorry about that.
Every 2 weeks he was paid. Okay, got it. Okay. So every 2 weeks he was paid a certain amount, but it was designed to be paid on a daily basis. And so that the way his contract, his agreement with them was, my pay, I get paid this much for this day.
Yes.
Okay, got it.
So under that compensation scheme, and by the way, that is the Supreme Court verbiage. I took that. I thought that was interesting. They actually used that. They used that term. Under that compensation scheme, Hewitt Mr. Hewitt earned over $200,000 annually. And Helix Energy basically said, hey, Michael Hewitt, you're exempt from the FLSA, exempt from overtime, because you are a qualified as a bona fide executive.
So they were treating him as if he was an exempt
Yes.
employee. And it makes sense, right? He had 12 or 16 individuals underneath him. So let's go back and look at that definition. He ran the tool pushing department, whatever that was. He had 12, I think you said 12 to 14 employees underneath him. Now, what we didn't say is, did he have authority over those employees in terms of hiring and firing? That may not have been in there. Was that in the document? I don't want to put you on the spot, but
yeah, no, he met all of the job duties.
Okay.
And that's it. Supreme Court. When I read through the document, they didn't dispute that he met all of those duties.
Okay.
Yeah.
Okay. All right. So all the duties were there. The question now comes into, well, let me find out. I want to know from you, what was the question? So he worked, right? So on his 28-day run, he would work, and then he would get 20 days off without pay.
Yeah.
And so he was still basically working 6 months and still getting over $200,000 a year.
Yes. So no matter how many hours he worked a week, he was paid that fixed amount per day. But this is where it gets a bit confusing. The key criteria to this case was salary basis. And in fact, there's a Department of Labor fact sheet, number 17G from the Department of Labor specifically says being paid on a salary basis means an employee regularly receives a predetermined amount of compensation each pay period on a weekly or less frequent basis, which could be every 2 weeks or something like that. But it would be on a weekly or a monthly basis. The predetermined amount cannot be reduced because of variations in quality and quantity of the employee's work. So the decisive question in this case was based on this definition and even deeper into the FLSA, was Hewitt actually paid on a salary basis per the law?
Well,
when you look at it first, I would say, yeah, he was. But the Supreme Court said no, and that Mr. Hewitt was eligible for overtime. And the reason they said that an employee whose paycheck is based solely on a daily rate is not considered paid on a salaried basis.
Wow. So they're saying because the agreement he had with the company, Hewitt's agreement with the company, was that he was going to get paid on a daily basis. He then doesn't have that. And then therefore they would have to give him overtime for any hours of 40 hours in a week that he would work. Correct? Is that what we're saying?
Say that again.
So basically we're saying because he was not an exempt employee, the Supreme Court saying, hey, you're not an exempt employee because of that daily rate. You're paying them on a daily rate. Then he would get overtime after 40 hours every week, right?
Exactly.
So he was probably getting around 44 hours of overtime every week.
Yes. And, here's the interesting thing. And if when you read into the documents, is that his 28 days on, let's say his 28 days ended, the pay period was, let's just say Sunday through Saturday overall.
Right.
And he worked, let's say day 27 was Sunday, day 28 was Monday. He'd get paid 2 days that week, but then he wouldn't be paid for that week, right? The rest of that week. And so, we know that if you work in a pay period as a salaried employee, except for the 7 exceptions, you have to be paid. And so that kind of played into this too. In fact, there was a 6. Yeah.
Got it. So
yeah.
You're saying, because depending on when he was starting and when the work week was, it's possible that some of his work was in the next week and he should have been getting paid for that full week if he was an exempt employee. But because he was being paid on a daily basis, so that would go into that and make that sound. Okay, that makes sense to me. All right, now I'm starting to see how all this connects. Yeah,
sure. Well, the company hung its hat on the fact that they were paying him way more than that $107,000 a year. So they were just saying, look, we're boatloads of money on a oil rig, boatloads, get it? Like boatloads of money on a floating oil rig. Yeah.
I didn't get that at first. Wow. My mind was a little slow this Friday morning. All right.
We're
good.
giving him boatloads of money. He meets all the other criteria, boatloads. At the end of the day, at the end of the year, he was making more than $107,000 a year. And you would think, oh, that was great. But there was a 6-3 decision that held that whenever an employee works at all in that week, right, he needs to get his full salary for that week. And that was not happening, regardless of the number of hours worked. And they actually talk about that in the new Supreme Court justice actually authored the opinion. She was one of the 6 that went that held for this. Given language, in a way, is a very narrow interpretation of the regulations. Believe it or not, the court actually relied on a dictionary definition of what the word salary means. They actually went into the Webster's Third International Dictionary. There were 2 different Merriam-Webster dictionaries that they looked at. And the word salary in the dictionary is defined as fixed compensation regularly paid as by the year, quarter, month, or week. And because of that definition and what they read into the FLSA, they held that his pay structure did not meet requirements because he was paid on a daily basis, which falls outside of that term weekly or less frequent basis.
Wow. I'm overwhelmed. And it is a very, 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 very narrow ruling, right? I mean, basically they're saying, look, you can't pay somebody that you think is exempt on a daily basis, right? You just can't do it. Salary basis means a week or more. Wow. Very narrow. Very interesting story here, Chuck. I think, kind of thinking about this, a couple of things that popped in my mind as you were kind of talking about this is one is salary basis. Again, we can't change a person's salary, an exempt person's salary based on quality or quantity of work. So I think that's kind of important for us to know and making sure that we do that. And so I think going through that, I think is really important to kind of look at that. It's interesting, Chuck. So let me ask you this. If they were paying him on a salary basis, so taking that 963, I don't have my calculator here, 963 times 7, whatever that is, and we're paying them that every week, that's what you get. And so every week that you work any part of that week, they would be exempt, right? I see you're getting your calculator out there.
Yeah. So let's just say, for fun and grins, they say, look, we're going to pay you $67.41 a week times 2. So we're going to pay you $13,482 for every week or every pay period.
Right. So that would be fine. That would make them exempt.
There would have been no problem here.
Right. And then if he had worked any part of that week,
boom.
Right. Then they would have had to pay him for that full week because we can't change. For our listeners, for an exempt employee, I know we're getting real minutia this week. I love it. For our exempt employees, we need to make sure that if they work any part of that week, they get paid for that week minus the 7 different exemptions, meaning if they're taking time off, a full day time off, full day suspension, FMLA, that kind of stuff, then we have to pay them for that time.
Yeah.
And so if he had worked into the next work week, then he would have been paid for that. Now, if he's working 28 days a week, it seems to me that they could have structured their work week, because we can structure it any way we want, as long as it's 7 consecutive days, to make sure that he's working within those 7 days. But again, with transportation out to the oil rig and all that kind of stuff, it becomes a lot. Wow.
Yeah. So let me give you what in you're on the and for our listeners, and I want to wrap it up here because I know minds are pretty blown. But here's a lot of times my final thought is to be careful when you're being creative with your compensation plans. Follow the rules. But in this case, if they had said, okay, Hewitt, you're making about $200,000 a year. We're going to go ahead and we're going to pay you no matter what, whether you're out on the platform or whether you're hanging out at home on your time off the platform, you're going to get boom, boom, boom. Teachers. A lot of times teachers are offered, when you sign up to be a teacher, you could say, I want to be paid based on the full year, 52 weeks. So spread my money out. Or I want to be paid just for the school year time. So when that summer comes, right, I'm not getting paid, but I know I'm getting more money during the school year. And I've seen that with teachers. So they could have done something very similar with him and just kept it going. And then, John, they could have said at the end of the year, we'll give you to make up for some of the extra time you put in and effort, we're going to give you a bonus.
Yeah. And
that's very possible. They could have given extra money. There's no problems with that. So,
okay.
Boom, drop the mic.
Woo! Okay, so a couple things that I want to remind our listeners. The states have very specific rules on how often you need to pay your workers, your employees. And so some states say you have to pay them every 2 weeks. Some say you have to do it twice a month. A lot of states will say for our exempt employees, you only have to do it once a month. But knowing what that is for your state is critical because you have to make sure that you're paying them properly. I got to share this story because it just popped in my head, Chuck. There was a story, right? So one of the ways that we're allowed in most states is to pay our employees cash for their pay, right? We can pay them in cash for their pay. So there was this gentleman, auto body shop owner, and one of their employees got into a tiff and the employee quit. Well, the auto body owner was very upset with this employee, very upset. And so decided that his last paycheck was going to be in pennies. So he drove to the guy's house, dumped the pennies on the guy's driveway, and pulled away.
Right.
Pennies are legal tender, and they could be paid that way. But where the owner went wrong is they didn't pay them soon enough, right? In their state, they had to pay them by a certain amount, certain time, did not meet that time. And so they got sued for that. But the pennies could have been justified. You could do that if you want, pay your employees in pennies. All right. So I want to throw one curveball at you, Chuck. So this is on an oil rig.
Mm-hmm.
And so what if that oil rig is past the 200-mile line? So it would be out in international waters. I'm assuming that we would not have to follow FLSA because it would be out in international waters. What's your guess?
That's beyond my scope. Maybe some of our listeners can interact with us and chime in.
Let us know.
All of our contact information is in the show notes below, as well as, by the way, work with Samantha, our wonderful producer, to make sure that the Supreme Court notes are the Supreme Court decision notes that Kajanji, I think, authored for that. Okay. So this is a really complicated story, John, but the bottom line is a daily rate will disqualify a person from being a salaried employee. It does not meet the salary basis. So just know that, and then boom.
And I think, I think that's probably something that has not, we'd have to go back and look history, has not been challenged by the Supreme, up to the Supreme Court, right? Has not been challenged in the court to say, hey, what is salary basis in terms of day rate, right? And so one of the things we're seeing, at least for a lot of non-exempt employees, we're seeing companies pay them every day. And so we're seeing that as a trend. And so I think that's some legal concerns here, right? And so again, I think that's thinking about that through that becomes so important on this. And I love that you got this story, and I love that it was a little bit detail oriented, a little bit out of our norm, but it does go back to that foundational of the Fair Labor Standard Act, right? Which is so important for us to understand in all of its things, right? Because we talk about exemptions, but boy, there are exemptions out there for many different things other than the 6 main ones, right? And so kind of diving into it on a really deeper level, knowing your industry. I always think about the automobile industry. Somehow in their lobbying efforts, they got it so that if you work in an automobile sell dealership, everyone there can be exempt pretty much, including your mechanics, which is, kind of crazy if you look at it from today's world, but back in 1938, maybe not so crazy.
Yeah.
And so kind of paying attention to that. The one thing I guess we should mention, Chuck, is that the Department of Labor, Wage and Hour Division, is looking at the federal minimum salary level. So right now, what Chuck talked about in the beginning of the story is set at $684 or $35,568 a year. There is a possibility that they're going to change that number up to like 913, we think, maybe as high. So here's what's going to happen. Probably in May, sometime between now and May, they're going to roll out that new number all through the summer. We'll have a chance for public comment. They will make a decision in the fall. Probably will roll out January 1st, 2024, but it's going to change budgets. It will change your budget because if you have people in that space between what it is now and what it's going to be, they were now being treated as exempt and now they'll be non-exempt. And then you have to think about overtime, or do you move them up above the new number? So kind of keep that in mind, probably something important to kind of throw out there to kind of make sure that we're thinking about going forward. When that happens, we will definitely be talking about it in Hot Topics for sure, and making sure that people are aware and knowing that. And we'll probably do some kind of stories on it as it goes out there, just so people are safe on there. All right, Chuck, what are your final thoughts? And then I have one thing to say before we leave.
I think I've gone through my final thoughts. So why don't you tell us, maybe share what's a preview of next week's story?
Hey, look at that. You're thinking you and I are on the same page. Yeah. So next week we are doing our, a story about retention in the workplace. And so not only are we going to talk about the story itself, but we're going to talk about ways we can retain employees for longer. And we will also going to have a information we will give away as part of that. So definitely tune in for that one and make sure that you're getting that information. Otherwise, we'll see you next week here at the HR Stories Podcast. Thank you for listening to the HR Stories Podcast. The material presented in this podcast is for informational purposes only. Chuck and John always recommend using an employment lawyer or HR consultant to handle any legal concerns or HR issues. We do our best to double check sources and make sure the information we are providing is accurate. We may eliminate or embellish without changing the basic narrative to make the story easier to understand. In certain circumstances, we may change identifying information to protect the innocent. The HR Stories broadcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the hrstoriesteam.com and learn more about how the team at HR Stories can support your business or nonprofit. Thank you for listening to the HR Stories Podcast, where there is a lesson in every story.